Okay, welcome to our next talk. Our next talk will be given by our duo, Pavel Urbaczka and Radim Kozub, co-founders of Blockchain Legal, Czech law firm focused on decentralized systems, and they will be talking about building parallel legal systems. Enjoy the talk.
Thank you very much for introduction. Ladies and gentlemen, this year's topic of Hackers Congress is New Order. It's definitely the new order of free individuals that are able to gain and maintain their freedom by using worldwide instruments. But anyway, these individuals definitely need some interactions between each other. And for these interactions, you will probably need also some rules. Our opinion is that these rules shall not be taken from existing state-based law, but rather from newly created legal systems. And these legal systems shall be voluntary, shall be definitely parallel to the existing legal systems. So our topic is building voluntary parallel legal systems, and let me briefly give you an overview of it. First of all, we'll try to explain what is voluntary parallel legal system, so anyway, what is the law, how it works. Then, why exactly we need parallel legal systems, voluntary one, why should we use them, and finally, how can we build them. So now let me give the floor to Pavel.
Thanks.
Start.
So let's start with the explanation of voluntary parallel legal system. I will firstly explain what is the legal system, then what is the parallel legal system, and then add the element of voluntary participation. The legal system is a complicated topic, and if we would look for a definition, we would find hundreds of them, and none of them would be complex enough and cover all relevant dimensions. So just for purpose of this presentation, I will use just a very simple one, which is that it is a system of rules issued by authority or observed by people during a longer period of time that is enforced. It has its own enforcement mechanism. So let me start with the system of rules. It is basically a set of rules, which is usually an orders, you have to do this, bans, you can't do this, or permissions, you can do this. These rules are general in their nature. What do I mean by that? I mean that they are connected, or they are attached to certain general categories of people and not just individuals. For example, some rule may apply to every citizen of Prague, but not in particular to me or Radim or Bob or Alice. Usually, the legal system comes from an authority such as the state or church. In this sense, the authority decides what is the law and basically runs the legal system. In most countries, the state power is legitimized by the theory of social contract or will of God. As you may know, according to the social contract theory, people surrendered some of their freedoms to state in exchange for protection of their remaining rights. Let's say that this is the, from the top-down creation of legal rules. But then we have a second possibility, which is a creation of legal rules from the bottom up. This is the case with the so-called customs. What are they? Well, they can be described as what has always been done and accepted by law. In other words, they are observed legal practices and traditions that relevant actors consider to be law. And the last part, not the least part, is the enforcement system, or the mechanism. When it comes to the law enforcement, we usually think only of state agencies and use of physical force. It is true that this enforcement mechanism is probably the strongest one, and every state uses it. However, this is not the only tool we have. First of all, there are also other kinds of mechanism, like positive enforcement mechanisms, such as providing the incentives to behave according to law, to act according to law. For example, it can be some rewards or benefits. Also, there are other kinds of non-violent enforcement mechanisms, such as social pressure. In extreme form, it can be an ostracism, that you are expelled from the community, or simply a loss of reputation. Especially reputation is probably going to play a more important role with the new technological possibilities we now have, including the sharing of information. So just to close this section, let me just point out a couple of legal systems that can be found in present. First of all, it's a civil law that can be found in continental Europe, Central America, and South America. Continental law is mostly based on legislative power, on the legislator. Then we have the common law, which is very similar and can be found in mostly English-speaking countries. But there's a difference, and it's basically about that the courts have a stronger power, and they participate on creating the legal rules through the so-called precedents. Then we have the customary law. Then we have the Then we have the customary law, as I talked previously, which can be found in several African countries. And finally, we have a religious law, such as the Sharia, Islamic law, which can also be found in Africa, Middle East, and Central Asia. So now we know what the legal system is. So let's get to parallel legal system. To put it simply, the parallel legal system exists when there are multiple legal systems within the same territory or within the same population or geographic area. It is typically the geographic area. Now, there is a whole theory of legal pluralism that many legal scholars study. Just to be clear, the parallel legal systems don't have to approach all individuals that are approached by the state law. They can overlap. There can be more parallel legal systems in one state's territory, or one parallel legal system covering more states' territory. Also, the parallel legal systems can be legitimized by the same means as the state's law. That is, the theory of social contract or God's will. To give a couple of examples of parallel legal systems, the most used is probably the Sharia law, which currently exists together with state legal system in several African countries, and is practiced even in some European communities, Muslim communities. It has its own generally defined set of rules and is enforced, usually by the community itself. We can also find other examples in many countries such as India, Tanzania, even Australia or Philippines. There is actually much written on this subject. However, in all these parallel legal systems we mentioned, there is one aspect missing, and that's the voluntary aspect. So what do we mean by that? There's clearly not any definition to be found. So according to us, there are two most important attributes are the voluntary opt-in possibility and voluntary opt-out. So what do we mean by that? Well, by voluntary opt-in, we mean that basically everyone is free to choose the legal system he wants to be part of. That suits him best. You know, actually, he may choose even more of them if the system allows such an option. However, it doesn't mean that the person has some indisputable right to be part of any legal system. Obviously, there can be some requirements for entering such a system. For example, the system can be tied to communities, to some institutions, or for example, you can ask the participants when opting in to provide, for example, a collateral or something like that. So this part actually ensures the likelihood of having the option to choose from different possibilities. But second, and probably the most important one, is the voluntary opt-out option. This basically means that everyone is able to quit the system, to leave the system, to opt out, if he doesn't like it anymore. It makes sense that in such a case, the opting out person should cover the costs incurred by the system. But we should be, careful with that, because if such costs are excessive or have devastating effects, then the opting out possibility wouldn't actually exist. It would be just a formal one. So, on the other hand, there should be some checks and balances. So people will not exit the system as soon, or due to their responsibilities related to their previous actions, for example, the breaches of rules. For example, by this I mean that I may try to leave the system as soon as I am obliged to do something unpleasant. So these checks and balances can be, for example, it's similar to the enforcement mechanism. It can be damage of reputation, it can be a community pressure, or, as I said, the loss of collateral, or even a cooperation of the legal system, mutual cooperation. So, do such systems exist, or can we find them in history? Well, if we can look through the history, we think that the closest system we can find is the medieval free city system, where, most of the citizens, not all of the people, but some citizens, or majority of them, were free to decide if they moved to the particular city, accepted the rules, and started doing business there. You had to physically move your location, but it wasn't that hard. Speaking about present day, well, to be honest, it's difficult to, or it's impossible to completely escape the state-based law and to migrate to voluntary parallel legal system. First of all, it's due to the fact that the state legal system doesn't have or doesn't allow you to opt out. And second of all, it's due to the fact that the voluntary parallel legal system, they don't exist in wider scale. However, we believe that new technologies, and especially internet and cryptocurrencies, will provide us the tools to build such system. With such technologies, it will be much easier to reach consensus in the community, transfer the necessary information, share them, and automate the relevant processes. People will be actually be able to voluntarily participate on creating and enforcing the rules. So that was about what is the voluntary parallel legal system. But should we actually prefer them over the state legal system we now have? Well, we think so, and we think so based on two main arguments. First of all, the ethical one, and second of all, the utilitarian one. So, speaking about the ethical argument, this one is actually pretty simple. We believe that neither individuals nor institutions have a supreme legal power over another individual without his own consent. No one should be able to force you to accept rules you don't agree with. Actually, no one should be able to use any physical force against you unless it's a defensive act. To us, as a result, the only ethically possible legal system is the voluntary one. Of course, you can argue that the theory of social contract gives you such a consent, but we're not big fans of this theory, and I don't know about you, but I don't feel like I gave any consent at all. So that's the first argument. The second argument is of utilitarian nature. We are convinced that the market forces and positive effects of competition applies not only to businesses in a classical business environment, but it also applies to legal jurisdictions and creating legal norms or rules. Competition of legal rules leads to creating better rules, objectively better rules. It is due to the fact that if you can opt out of system with perverse legal rules, then there inherently exists an incentive for the system to stay away from such a distortion. And if there are some rules that are bad, then there's an incentive to change them to please the participants. If you don't do that, then people just leave. They opt out. Also, with different legal systems, everyone can see which legal rules actually work in practice and which don't. So you can compare the legal rules. In case of one and only system, these forces don't exist. And we have to rely on other ineffective and extreme mechanisms, such as immigration or even revolution. A typical example of suppression of competition of legal rules is European Union. On one hand, we can see the positive effects of harmonization. It's definitely true. I can't deny that it's valuable to some businesses. On the other hand, we are starting to lack the competitive aspects in creating these rules, because the harmonization is not spontaneous. It's forced from the top to bottom. So in the near future, it will be probably almost impossible to escape these rules, even if they're bad. And it will be the same in every EU member state. We will not be able to compare the solutions, because there will be only one of them. And we will not be able even to foot vote for different jurisdictions. So, according to this argument, we believe that in comparison with the state legal system, the voluntary one will have lower costs, higher efficiency, and it will be more flexible and adaptive to the participant needs. So that's for my part. Now Radim will take it.
Mm-hmm. So now, let's look at the question, how can we build the voluntary systems? We will divide it into two parts. So what are the preconditions for it? And then, how exactly can you do it? The examples. Now, the preconditions. It's identification of the voluntary system, constitution, legal rules, opt-in and opt-out principles and rules, and enforcement mechanism. First, the identification. Every legal system, including the voluntary one, has to be somehow identified. It's usually done by the relationship to some entity, organization, community that maintains this legal system. On the other hand, it's not necessary, because you can simply decide for your own legal system that you will just follow it, and you don't need to attach it to some identity. However, if we want to build something that was for ages made by states, by churches, that even derive their power from some divine activities, we should be able to communicate it transparently and in understandable form. What is the Constitution? Don't be confused by the legal term, because of course it's not the state-based law Constitution, it's the set of some essential rules. What kind of rules? These rules shall be actually the rules that won't be changed, or if changed, there should be very wide agreement, maybe consensus of all participants, that they could be changed. So these rules actually can express some principles of the system. For example, we can use non-aggression principle. This can be the constitution of some voluntary legal system. Then we need, of course, some legal rules. So this is, let's say, the body of the law. Legal rules in state-based system are actually the rules that you should either follow strictly, or you can agree something else if you are somehow allowed to do so. For example, if you're transferring the real estate. In Czech law, if you do so, you need to do it in a written form. If you don't do it in a written form, it's invalid, so you can only agree something else if there is if you're permitted to do so. What is the nature of such a rules in voluntary system? There are two possible views. First is best practice rules. So if some rule is used for some longer time by quite wide range of participants, it will probably become the best practice, something that is somehow recommended by the participants to be used. So if you follow best practice rule, you should take an advantage of it. For example, if there is a best practice rule to transfer the real estate in written form, then if you do it, it should be clear what rules have you agreed. If you did it orally, there can be some unclear moments. Soft law is another view, and this is actually the situation when you have not agreed some rule for some situation, or you just agreed the rules for part of it. So in case there is some dispute and the court, the arbitrator, need a rule, then he will probably use these legal rules that probably also serves as a best practice rules at the same time, and use them as a law. But it doesn't mean you can't agree something different. That's the difference between state-based law or involuntary law and voluntary law. And of course, the sources will be also a bit different from state-based law, especially there will be big significance of contractual practice, because the contracts that are used will be probably the basis for more generalized rules in practice. Opt-in and opt-out rules. It can be very easy that the participant just express his will to follow the voluntary system, or there can be some requirements, and requirements will be usually imposed by some community or entity that is the creator, that is the main identity related to it. So as a matter of law and fact as well, you can follow every voluntary legal system, but you can be required to meet some requirements if you want to identify yourself with the community. Partial opt-in and opt-out, that could be possible. On the other hand, could be also limited or even excluded. So imagine that you are the member of some entity, some, let's say, non-profit organization, and you decide just to opt out from some essential rules. That can be excluded, sorry. On the other hand, it can be allowed, depends. Enforcement mechanisms. In state-based law, in liberal democracies, the sanctions are usually start with some monetary sanction that affects your property. Then they are followed by coercive force against your property or your physical integrity. It is actually not principally excluded in voluntary system, because voluntary doesn't mean you do have to everything voluntary. It means that you have to voluntarily consent that the coercive force can be applied against you in case of breach of the law. On the other hand, definitely there will be a big significance of reputation mechanism, because, first of all, they're very flexible and they allow different communities, entities to develop their own way of doing it. So it can start with some certain level of distrust that is applied by the community and lead to the full ostracization, depends on the intensity. With regards to coercion, actually, to keep it really voluntary, it should work especially in case of some harm to the other individual or the risk of such a harm, usually significant proprietary harm or physical harm. I will talk about a bit later how it can work in practice. So now let's do it. How exactly can we do it? So let me give you some examples. Find or create the identity, or do it your own way. Reach the consensus on essential rules, summarize and create the rules for specific situations, the legal rules. Enable opt-in and opt-out, and find the right enforcement mechanism. Identity. We are speaking on the floor of Paralelní Polis. This is a nice example of community that you can join, actually, because it exists, or you can build your own Paralelní Polis in your own city, in your own country. As I said, it's not necessary because we just can do it on our own. So if you now express, I'm going to follow non-aggression principle, and this is my legal system I applied for, all right, no problem. Constitution. I would always recommend to keep minimalistic approach, because to make it work, it should be really consensual. And achieving consensus is actually the most difficult activity in decision-making in human world. So minimalistic approach, and actually more specific you will be, higher risk of some disagreement of part of the community or participants to the system you're creating. Legal rules. Legal rules are actually some most, or should be, I'm not saying it's always, but it should be most efficient way of dealing with some social or economic relationships. Now, the relationships are naturally more global, so even the solution should be more global, and therefore, the various systems should inspire each other. In voluntary system, it could be also a contractual practice I mentioned, worldwide, that could inspire the law, the creation of the law. So, what can you do? Find the legal documents and turn them into template. You want to build a decentralized marketplace within your community, try to be inspired by already existing ones. Use the open source documents, for example, SAFT template for token sales. It's plenty of them on the internet, but also if you use it, I mean, if you create the voluntary system, open source your documents, try to help it. And definitely incentivize the community to develop and work on legal documents. This is pretty important, because once it's not going to be done, it starts to be obsolete and it's not going to be used. So if you incentivize the community in the right way, you will increase the chance that the contractual practice, which is always the fastest one in law, will be somehow turned into the legal practice. Opt-in and opt-out rules, as I said, don't underestimate this process. If you don't want anyone to be part of your community and to express his relation to the legal system, make some requirements. That's it. And of course, don't impose big burdens on opting out, otherwise it doesn't have to be the voluntary system. Enforcement mechanism, there is always the strong community aspect, so let the community to develop their own mechanisms. Anyway, if you don't agree with some development, just push the discussion. If you want someone not to cooperate with someone else who already breached the law, and he doesn't want to do it, don't cooperate with him. That's it. Regarding the coercion, as I said, it's very complicated, and the reason is very simple. It's actually because the state-based law and state has the exclusive power, and maintain it, to the violence. So the only exception for you is a defensive violence under some specific rules and circumstances. If you maintain the violence as a punishment in your legal system, it will be considered a violence and will be punished, of course, by the state. So now we have the situation of conflict with state-based law. What can we do? First of all, try to avoid the conflict in general. If you're not able to avoid the conflict, consider all risks, and after you assess them, ask yourself, in worst case scenario, are you ready to face all consequences that may happen? If you answer yes, do it. If you answer no, then follow the state-based law to the extent you're not able to face the consequences of its breach. Definitely, if you breach the law, minimize the negative consequences, and if this is the breach that lasts for a longer time, then assess it on a regular basis. And again, if you're in the situation you don't want to, or that may lead to the consequences you don't want to face, just adjust your breach to the level that you're able to keep the consequences in the way that you want to face. So that's it. Thank you very much. And now, if you have any questions, please ask them.
Thank you. Many questions? Okay.
Hi there. Is it possible to just look at that last slide and just relate that again with a practical example? So if you were to have a parallel contractual legal structure, can you give an example of what that might be and how this might play in parallel with...
With conflict with state law?
Yeah, with an example that you might imagine.
All right, so I will use a very, very easy example. So let's imagine that you have the community of paralelní Polis, and someone actually breached the contract with someone else, so he'll produce the loss to him in worth of €1 million. Yeah? And you know that you have some technical instruments to take his crypto in case he's not going to comply with the law. So if you do it, well, you will be probably sued for theft by the state-based law. So you should ask yourself, am I going to face it? Yeah, because there can be some legal argumentation that you were forced to do it because it was your only chance. So it was very extreme situation. But finally, you could go to jail for it. Yeah? So that's it. But anyway, you should consult it. You should think of the way how to do it with as minimal conflict with the state-based law as possible, if you don't want to go to jail, of course.
Thank you. Can you explain what's the main difference between such voluntary legal system and just a commercial contract? What's the principal difference with, let's say, my health insurance when I have some obligations and I'm getting some benefits?
Yes. The principal difference is that the commercial contract is being agreed and maintained under some legal system, always. So if you do it without Anything else, it will be probably some state-based legal system in case of some breach. It could be enforced by the state power of some state and so on. If it's, so the difference is that if you want to enter into this contract within the voluntary legal system, you would have to probably opt in for some voluntary legal system. Yeah? So then, if you did it before, and you sign the contract, and maybe you start to use it, so you can propose it by many ways to be the best practice within the community that is using the voluntary legal system you opted in. That's the process. So the difference is it's different activity, yeah, because it's going to be the law probably. If you were willing and if you expressed your will to be bound by the contract, it will be the law. But we are proposing the new concept of creating some new legal systems, of course, that are not expressly acknowledged by already existing state powers because of these social contract theories and so on. But this is different. If yeah, understand? All right.
My question is, what's your plan, or what's your idea? How do you solve the problem of identity? Because especially in Parallel Polis, members change their identities and they're mixed IDs. So actually, I still don't know who is who. So
Yeah.
how do you want to write down the contract even if you don't know the person who is signing the contract?
Sure. Just to be clear, you mean like the identity of the person? We are not talking about the identity of the system itself, right? All right. I think like technically and legally there is several ways how to do it. Of course, if I don't know the identity of the other contracting party, I should take some collateral in order to be able to enforce it. Yeah? So this is one of the ways. Anyway, I think the smuggler on Friday had an excellent talk about it. How can we do it like in crypto anarchy model, so collateralizing the relationships or the agreements. So this could be one of the way, or then reputation. If it's reputed, so it's up to me if I'm going to believe will comply with the law or he will breach it. Maybe we'll find thousands of others. You could probably know more than me. But these two, I think, are like the best example we can have right now, and there are also that could be also used in existing reality, more or less.
Hello.
Hi.
Is it a prerequisite for the state legal system to acknowledge that there is a parallel system in place so that nobody can switch back and go to the state legal system when the result of the arbitration or whatever happens under the parallel legal system is not in their favor? And if it's not a requirement, what are those legal jurisdictions, in your knowledge, that are more tolerant to the existence of parallel legal systems, so that go there and establish one? And if schemes of property could provide some, let's say, at least territorial platform for parallel legal systems to exist, other walled communities or such schemes where you may say that, you know what, this is a domestic rule where we can apply whatever, a domestic
To create the voluntary system,
yes,
the territories.
create there so that you can keep the state out and keep the participants in the parallel systems from resorting to the legal system when it's not their favor to be in the parallel system.
Yeah. Thank you. Well, first question, prerequisite, it's actually not prerequisite, and from the current position of state-based legal system as state in general, it's very often legally as a matter of constitutional law, it's impossible because there is one principle of state-based law, and this is so-called, in Latin it's denegatio justitiae, which means like the ban of refusing the justice. So anyone comes to the state and asks for justice, so if this is within its territory and the application of its law, the state is actually has a duty to provide him justice, to sue it. The only exemptions can be the exemptions made by state law, which is, for example, arbitration. Yeah? So I think in most of the states it's just impossible. So building the voluntary parallel legal system has to be independent of this situation, and will be something that that is happening in parallel space. So, I mean, nice practical example is reputation. So if you buy something, if you buy, let's say, some electronic device for 1,000 crowns, yeah, you won't probably sue the seller if it doesn't work because it's too complicated and it's too costly. You will probably write bad referration. So the motivation of the seller to not to have the bad referrations and bad reputation finally is stronger than to be sued because he has thousands of lawyers and he don't have to care about it. So this is actually the example of it, and it's possible to do it in an organized way. Another question, if there are some states, I wouldn't say there is any jurisdiction, maybe except of Liberland. This is the only example of really liberal jurisdictions that will provide such an option. I would just look at the liberal democratic state when you have your contractual freedom quite wide, because this is actually one of the prerequisites to be able to sustainably build something. In my opinion, in the Czech Republic, it's not so bad situation for it. It might be, for example, some Anglo-Saxon legal system that respects like more the forms, different forms of contracts and so on. But I'm not sure about that. I would say just that it's better to think of where to build, or if even build it on the territory or in virtual space first, because virtual space will probably be the better space right now to build it.
Very interesting talk, thank you. I'm wondering if a voluntary legal system such as the ones you described is based upon perhaps a physical location, like for example here in Polis, if we say we want to create a private legal system where if you're on this property then it applies to you. It starts to kind of look like a state, right? Because it's like once you're inside the borders, the laws start to apply to you. Would you say that is the case? And if so, in that case, what would you say would be the key differentiating factor between that kind of legal system and a state legal system?
It could be the case, and probably will, because within this concrete community in Prague, it will work this way. But when I talked about Paralelní Polis, I should mention that I'm more thinking of the cloud community that the Paralelní Polis tries to create. So this is probably the answer. Like, it's much more suitable for right now, for creating it in cloud communities. So it doesn't matter if you're physically here in Prague or somewhere else, because the means of enforcement should apply to you if you're anywhere, because of the electronic networks we can use for it. So this is right now the principal difference, that it will be much easier to do it in virtual space. But anyway, even if it's here, for example, still the difference will be, if you escape, let's say, if you bridge the wall and escape from Prague, so you steal something from the Bitcoin coffee here, well, of course it will be hard to punish you, but the principle of enforcement will still work. So at least you will be ostracized from the Prague community here. But as I said, it will be probably connected to the cloud community that will try to enforce this law against you.
Okay, so last question.
It will be short. Isn't the main key the difference between the state and this paralegal system, that the option in and option out, basically? Because it's I see it's contractual more than the social contract, but real contract.
Yeah, in principle, because in state-based system, you're just bound by the state law because you're on the territory of the state, because there is this territorial power and sovereignty of the state. In voluntary legal system, it's your consent. You want to opt in, you want to opt out. Right. Maybe someone.
Yeah, unfortunately, we don't have time for more questions, but we can like decentralize the discussion and continue elsewhere. So thank you very much for your talk.
Thank you.